Part 1 and Letter A, Substantive Law versus Remedial Law. Substantive law is that part of the law which creates, defines, and regulates rights, or which regulates the rights and duties which give rise to a cause of action. It creates vested rights. If the rule takes away a vested right, it is not procedural. If the rule creates a right, such as the right to appeal, it may be classified as a substantive matter. By its very nature and essence, substantive law operates prospectively, while remedial law prescribes the method of enforcing rights or obtains redress for their invasion. There is no vested right that can be attached to or nor rise from procedural laws. If it operates as a means of implementing an existing right, then the rule deals merely with procedure. A person has no vested right in any particular remedy, and a litigant cannot insist on the application to the trial of his case, whether civil or criminal, at any other than the existing rules of procedure. Remedial law is construed to be applicable to actions pending and undetermined at the time of their passage and are deemed retroactive in that sense and to that extent. As a general rule, the retroactive application of procedural laws cannot be considered violative of any personal rights because no vested right may attach to nor arise therefrom. In the case of Culminar versus Culminar, GR 252467, June 21, 2021, the 2019 amendments shall govern all pending cases commenced before they took effect on May 1, 2020, except to the extent that in the opinion of the court, their application would not be feasible or would work injustice, in which case the procedure under which the cases were filed shall govern. In this case, the case commenced with the filing of the complaint in September 2018 and remained pending when the 2019 amendments took effect. As it was, Judge Gill applied Section 12, Rule 8 of the 2019 amendments when, according to the court, she supposedly resolved motu proprio, the affirmative defense of respondent companies. That is, the complaint failed to state a cause of action. The records, though, readily show that when Judge Gill motu proprio resolved the affirmative defenses on May 22, 2020, the prescribed 30-day period had long expired. ProFriends filed its answer with affirmative defense in December 2018, PEC and Crescenta Realty on January 2019, and Amaya on February 27, 2020. Judge Gill accordingly should have therefore desisted from applying the 2019 amendments to the case, specifically Section 12, Rule 8 thereof, because when she did, the same was no longer feasible. Next, a violation of substantive law cannot simply be disregarded. The procedure laid out in Section 21, Article 2 of RA 9165 is considered substantive law and not merely a procedural technicality. The law requires that the police authorities implementing RA 9165 strictly comply with the chain of custody procedure, although failure to strictly do so does not, ipso facto, render the seizure and custody over the illegal drugs as void and invalid if, letter A, there is justifiable ground for such noncompliance, and B, the integrity and evidentiary value of the seized evidence were preserved. In this case, however, there was total lack of compliance. A review of the pieces of evidence submitted by the parties show that an inventory report was not accomplished by any of the police officers. In fact, an inventory report was never mentioned in all the transmittal documents accomplished by the concerned authorities. Absent the inventory report, the required presence of the insulating witnesses cannot be considered to have been complied with, consequently rendering a judgment of conviction without being able to establish that petitioner, along with the required witnesses under Section 21 of RA 9165, were able to personally see the movement of the seized drugs amounts to a violation of substantive law. This is the case of Uy versus People, GR 217097, 2022, decided by Justice Hernando. Letter B is the rule-making power of the Supreme Court. The scope of the rule-making power of the Supreme Court is to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. The scope of judicial power is or includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality. The Supreme Court has the sole prerogative to amend, repeal, or establish new rules. Therefore, the rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Congress has no authority to encroach upon the rule-making power of the court. When Congress passed the first paragraph of Section 14 RA 6770, and in doing so took away from the courts their power to issue a TRO and or a writ of preliminary injunction to enjoin an investigation conducted by the Ombudsman, it encroached upon this court's constitutional rulemaking authority. These issuances, which are by nature provisional reliefs and auxiliary writs created under the provisions of the Rules of Court, are matters of procedure which belong exclusively within the province of the Supreme Court. Rule 58 of the Rules of Court did not create, define, and regulate a right, but merely prescribe the means of implementing an existing right, since it only provided for temporary reliefs to preserve the applicant's right in esse, which is threatened to be violated during the course of a pending litigation. This is Carpio Morales versus Court of Appeals, GR 217126-27, November 2015. All of judicial hierarchy. A case must be filed with the lowest court possible having the appropriate jurisdiction. Other invocation of the Supreme Court is improper. It applies generally to cases involving factual questions, as it is not a trial of facts. The court cannot entertain cases involving factual issues. The Supreme Court is a court of last resort and must so remain if it is to satisfactorily perform the functions assigned to it by the fundamental charter and immemorial tradition. It cannot and should not be burdened with the task of dealing with causes in the first instance. Its original jurisdiction to issue the so-called extraordinary writs should be exercised only where absolutely necessary or where serious and important reasons exist therefor. From the case of Linsangan Maldia versus Philippine Deposit Insurance, the principle of judicial hierarchy of courts provides that the appropriate forum is the court lowest in the judicial hierarchy. The rationale being twofold, namely, A, it would be an imposition upon the precious time of the higher courts, and B, it would cause an inevitable and resultant delay, intended or otherwise, in the adjudication of cases, that some of these cases may have to be remanded or referred to the lower court as the proper form under the rules of procedure, or because these courts are better equipped to resolve the issue given that this court is not a trier of facts. Exceptions. When petitioners rightly claim that they had no other plain, speedy, and adequate remedy in the ordinary court of law that could free them from the injurious effects of respondents' acts in violation of their right to freedom of expression. Number 2, cases of first impression. 3, the constitutional issues raised are better decided by the court. 4, exigency in certain situations. 5, the filed petition reviews act of constitutional organ. 6, when there are genuine issues of constitutionality that must be addressed at the most immediate time. 7, when the issues involved are of transcendental importance. And 8, the petition includes questions that are dictated by public welfare and the advancement of public policy, or demanded by the broader interests of justice, or the orders complained of were found to be patent nullities, or the appeal was considered as clear and inappropriate remedy. Novelty of the issues alone is not an exemption to the principle of judicial hierarchy. Generally, a direct invocation of the court's original jurisdiction to issue extraordinary writs should be allowed only when there are special and important reasons thereof. Thus, in Rama versus Moises, the court recognized the following exceptions to the strict application of the rule on hierarchy of courts. A, when there are genuine issues of constitutionality that must be addressed at the most immediate time. B, when the issues involved are of transcendental importance. C, cases of first impression. And D, when the constitutional issues raised are best decided by this court. Lastly, when the time element presented in this case cannot be ignored. Notwithstanding the foregoing, while the court notes that the petition presents at the very least a case of first impression, novelty alone cannot cure the inherent defects of the petition. Those who seek relief from the court must comply with its rules. This is the case of Mercado versus Lopena, GR 23017T, June 2018. Special and important reasons must be clearly stated in a petition for certiorari filed before the Supreme Court. The invocation of this court's original jurisdiction to issue writs of certiorari has been allowed in certain instances on the ground of special and important reasons clearly stated in the petition. Palafox Jr. filed his petition directly to the Supreme Court despite the concurrent jurisdiction of the appellate court. Significantly, he did not bother to provide any reason or explanation to justify his noncompliance to the rule on hierarchy of courts. Further, when he was required to reply to Senator Angara's comment containing the latter's argument on the violation of hierarchy of courts, he simply manifested his adoption of his previous arguments in the petition. This constitutes a clear disregard of the hierarchy of courts and merits the dismissal of the petition. This is the case of Palafox Jr. versus Mendiola, GR 209551, 2021 case, penned by Justice Hernando. Next is the doctrine of non-interference or judicial stability. The doctrine of non-interference or judicial stability provides that no court, has the power to interfere by injunction with the judgments or decrees of a court of concurrent or coordinate jurisdiction having the power to grant the relief sought by the injunction. This is the case of Tan versus Cinco. The rationale for the rule is founded on the concept of jurisdiction. A court that acquires jurisdiction over the case and renders judgment therein has jurisdiction over its judgment to the exclusion of all other coordinate courts for its execution and over all its incidents, and to control, in furtherance of justice, the conduct of ministerial officers acting in connection with this judgment. That's the case of Barroso versus Omelia. It also bars a court from reviewing or interfering with the judgment of a co-equal court over which it has no appellate jurisdiction or power to review. Villamor versus Salas. Exception. The doctrine of judicial stability does not apply where a third-party claimant is involved. In the case of Traders Royal Bank versus IAC. This also applies to judicial courts and administrative bodies, where the law provides for an appeal from the decisions of administrative bodies to the Supreme Court or the Court of Appeals. It means that such bodies are co-equal with the regional trial courts in terms of rank and stature, and logically beyond the control of the latter. Hence, the trial court cannot interfere with the decision of such administrative bodies. The RTC is a co-equal body of the Securities and Exchange Commission. Hence, it has no power to control the other. Pursuant to the exercise of its quasi-judicial jurisdiction, the SEC stands as a co-equal body of the RTC. Hence, all orders and issuances issued by the SEC in the exercise of such jurisdiction may not be interfered with, let alone overturned by the RTC. If any or all of said orders are erroneous, the Organic Act creating the Commission, PD 902-A, provides the appropriate remedy, first within the Commission itself and ultimately in this court, the Supreme Court. Nowhere does the law empower any RTC to interfere with the orders of the Commission, not even on grounds of due process or jurisdiction. The Commission is conceding arguendo a possible claim of respondents, at the very least a co-equal body with the RTC. Even as such co-equal, one would have no power to control the other. But the truth of the matter is that only the Supreme Court can enjoin and correct any situation of the Commission. Rizal Commercial Bank, King Corporation versus Plus Print Industries, GR 199308 2019. Trial courts having the equal authority should not interfere with their respective cases. The RTC Branch 10 clearly had no authority or jurisdiction to disturb the final and executory decision dated August 3, 1990 of the RTC Branch 8, a co-equal court in civil case number 1465. The court held that the various trial courts of a province or city having the same or equal authority should not, cannot, and are not permitted to interfere with their respective cases, much less with their orders or judgments. Despite this, the RTC Branch 10 acted capriciously and overstepped its jurisdiction when it ordered the execution pending appeal merely by reason of Patricia's alleged old age. Verily, the apparent old age of Patricia would certainly not override the doctrine that a court cannot and should not disturb the orders or judgments of a co-equal court, especially since the said decision is already final and executory. This is the case of heirs of Rio Casino Senior versus Development Bank of the Philippines, Malabalay Branch, GR 204052-23, penned by Justice Hernando. Another case, violation of the doctrine of judicial stability renders proceedings void for lack of jurisdiction. Trackworks petition for certiorari, prohibition, and mandamus filed before the RTC of Makati City was improper and in glaring violation of the doctrine of judicial stability. The RTC of Pasig City's denial of the injunctive relief sought by Trackworks in its orders dated January 4, 2010, March 15, 2010, and May 28, 2010, and all other incidents arising therefrom may not be interfered with by the RTC of Makati City. A court of concurrent jurisdiction for the power to open, modify, or vacate the said orders is not only possessed but is restricted to the court in which the order is issued. Consequently, the RTC of Makati City has no jurisdiction over Trackworks petition, rendering all the proceedings therein as well as the June 14, 2012 decision and other orders issued thereon void for lack of jurisdiction. Metro Rail Transit Development Corporation versus Trackworks Rail Transit Advertising, Vending and Promotions, GR 204452, June 28, 2021, by Justice Hernando. Next, jurisdiction. Jurisdiction is the power and authority of a court to hear, try, and decide a case, as well as to enforce or execute its judgment or orders that have become final. It is both a substantive and procedural law. Jurisdiction over the subject matter is substantive as it is conferred by the Constitution or by law, while jurisdiction over the person is procedural as it is acquired by a party's voluntary submission to the authority of the court or through the exercise of its coercive processes. Jurisdiction over the rest is likewise procedural as it is obtained by actual or constructive seizure, placing the property under the orders of the court. Original jurisdiction versus appellate. Original jurisdiction means jurisdiction to take cognizance of a cause as its inception, try it, and pass judgment upon the law and facts. Appellate jurisdiction is courts of appellate jurisdiction have the power to review, revise, reverse, and modify a lower court's decision or order. When we say general jurisdiction versus special jurisdiction, because courts, not courts, but courts of general jurisdiction are those that have jurisdiction over all kinds of cases, such as civil and criminal cases, and other cases that do not fall within the jurisdiction of special courts or courts of limited jurisdiction, which goes to say that special jurisdiction exercise limited jurisdiction over specific cases conferred by special law. Exclusive versus concurrent. Exclusive original jurisdiction precludes the idea of coexistence and refers to jurisdiction possessed to the exclusion of others, while for concurrent is the power conferred upon different courts, whether of the same or different ranks, to take cognizance at the same stage of the same case in the same or different judicial territories. Where there is concurrent jurisdiction, the court first taking cognizance of the case assumes jurisdiction to the exclusion of other courts. That brings us to the definition of the doctrine of adherence to jurisdiction or continuity of jurisdiction. The doctrine provides that once a court has acquired jurisdiction, such jurisdiction cannot be ousted by subsequent events, although of a character which would have prevented jurisdiction from attaching in the first instance. Once jurisdiction has been acquired, it continues until the court finally disposes of the case. Exceptions are the following: when the new law expressly provides for a retroactive application, when the change of jurisdiction is curative in character, Next is the jurisdiction of various Philippine courts and tribunals. For civil case, this is the exclusive original jurisdiction of Supreme Court. Petitions for certiorari, prohibition, or mandamus against, number 1, Court of Appeals. Number 2, Commission on Election. 3, Commission on Audit. 4, Court of Tax Appeals. 5, disciplinary proceedings against members of the bar and court personnels. Concurrent jurisdiction with the RTC. Number 1, cases affecting ambassadors, other public ministers, and consuls. Concurrent jurisdiction with CA, petitions for certiorari, prohibition, or mandamus against RTC. On Civil Service Commissions, Central Board of Assessment Appeals, National Labor Relations Commission, other quasi-judicial agencies. Now, petition for writ of kalikasan also is with concurrent jurisdiction with CA for certiorari, prohibition, or mandamus. With the CA and RTC, concurrent with the CA and RTC, petitions for habeas corpus, petition for quo warranto, petitions for certiorari, prohibition, or mandamus against inferior courts and other bodies, BP 129, Section 9, Paragraph 1, and Section 21, Paragraph 1, Constitution, Article 8. Petitions for continuing mandamus. Now, with RTC, CA, and Sandigan Bayan, petition for writ of amparo, petitions for writ of habeas corpus, and appellate. The appellate jurisdiction under the civil cases of the Supreme Court by way of appeal by certiorari under Rule 45 against 1 to 5, Court of Appeals, Sandigan Bayan, RTC on pure questions of law, in cases involving constitutionality or validity of a law, or treaty, international agreement, or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation, legality of a tax, imposed assessment, toll, or penalty, jurisdiction of a lower court. Finally, Court of Tax Appeal and Bank as the appellate jurisdiction of Supreme Court under the civil case. For CA, the exclusive original jurisdiction of Court of Appeals. These are actions for annulment of judgments of the RTC. The Court of Appeals may act as a trial court in the following instances. In annulment of judgment. Number 2, when a motion for new trial is granted by the Court of Appeals. Number 3, a petition for habeas corpus shall be set for hearing. Number 4, to resolve factual issues in cases within its original and appellate jurisdiction. Number 5, in cases of new trial based on newly discovered evidence. Number 6, in cases involving claims for damages arising from provisional remedies. Number 7, writ of amparo proceeding. 8, writ of kalikasan proceeding. And 9, writ of habeas data proceedings. So, Court of Appeal, and under its exclusive original jurisdiction for actions for annulment of judgment, but the Court of Appeals may act as a trial court in the following instances 1 to 9. Concurrent jurisdiction with Supreme Court. Petitions for certiorari, prohibition, or mandamus against RTC, CSC or Civil Service Commission, CBAA or the Central Board of Assessment Appeals, NLRC, and other quasi-judicial agencies. Number 2, petition for writ of kalikasan still. With RTC, with Supreme Court and RTC, petition for habeas corpus, petition for quo warranto, petitions for certiorari, prohibition, or mandamus against inferior courts and other bodies, and petitions for continuing mandamus. They have a concurrent jurisdiction with the Supreme Court, the RTC. With RTC Supreme Court in Sandigan Bayan, that is petition for writ of amparo, petitions for writ of habeas data. Exclusive appellate jurisdiction of the CA by way of ordinary appeal from the RTC and the family courts. Rule of Courts, Rule 41, otherwise known as the family courts. Number 2, by way of petition for review from the RTC rendered in excess of its appellate jurisdiction, using Rule 42, that's exclusive appellate jurisdiction. By way of petition for review from the decisions, resolution, orders, or awards of the Civil Service Commission, Office of the Ombudsman in administrative disciplinary cases and other bodies mentioned in Rule 43, by way of ordinary appeal over decision of MTCs in cadastral or land registration cases pursuant to its delegated jurisdiction as the exclusive appellate jurisdiction. Court of Tax Appeals and Bank. In bank, exclusive appellate decisions or resolutions on motions for reconsideration and new trial of the court in division in the exercise of its exclusive appellate jurisdiction over cases arising from administrative agencies, from local tax cases decided by the RTC in its original jurisdiction. So RTC in its original jurisdiction, that's the exclusive appellate jurisdiction or review under tax CTA in bank. Decisions, resolution, and orders of the RTC in local tax cases resolve the exercise of their appellate jurisdiction. Decisions, resolution, or order of RTC in tax collection cases, and orders on motion of reconsideration of the new trial of the court in division, and the decision of CBAA in the exercise of its appellate jurisdiction. Court of Tax Appeal Division. Division. This is division. That's its exclusive original or appellate. Decisions of the CIR in cases involving disputed assessment, refunds of internal revenue taxes, fees or other charges, penalties in relation thereto, or other matters arising from the NIRC or other laws administered by the BIR. Number 2, inaction of the CIR in cases involving the same above. And decisions, resolutions, or orders of the RTC in local tax cases decided or resolved by them in the exercise of their original jurisdiction. Decisions of the Commissioner of Customs in cases involving liability of customs duties, fees, or other money charges, seizure, detention, or release of property affected, fine, forfeiture, in custom laws, other administered by the Bureau of Customs, and decision of the Secretary of Finance on custom cases elevated to him automatically for review from decisions of the Commissioner of Customs, adverse to the government under Section 2315 of the Tariff and Custom Code. And finally, the decision of the Secretary of Trade and Industry in the case of non-agricultural product, commodity, or article, and the Secretary of Agriculture in the case of agricultural product, commodity, or article involving dumping and countervailing duties under Section 301 and 302 respectively of the Tariff and Custom Code. How about their exclusive? Exclusive jurisdiction is tax collection cases to it. Regional jurisdiction in tax collection cases. Appellate jurisdiction over appeals from the judgment, resolution, orders of the RTC in tax collection cases originally decided within their respective territorial jurisdiction. Now for the Sandigan Bayan, they have original exclusive jurisdiction over cases involving violations of the EO number 1, creating the PCGG, EO number 2, the illegal acquisition and misappropriation of Ferdinand Marcos, Imelda Marcos, and their close relatives, subordinates, business associate, dummies, agents, or nominees. EO number 14, cases involving the ill-gotten wealth of the immediately mentioned persons, Marcoses. EO number 14-A, amendment of EO number 14, which is otherwise known as the Act strengthening further the functional and structural organization of the Sandiganbayan. Concurrent jurisdiction with the Supreme Court would be petitions for certiorari, prohibition, and mandamus, whether or not in aid of its appellate jurisdiction, and petitions for habeas corpus, injunction, and other ancillary writs in aid of its appellate jurisdiction, including quo warranto, arising in cases falling under EO numbers 1 to 14 and 14-A. Now, with Supreme Court, CA, and RTC, concurrent jurisdiction with the Supreme Court, CA, and RTC, petitions for writ of amparo, petitions for writ of habeas data, known as the writ of habeas data. That's the same. For the regional trial courts, exclusive original, in all civil actions in which the subject of the litigation is incapable of pecuniary estimation, that would be regional trial court under BP 129, Section 19. Note, to determine whether or not a subject matter is incapable of pecuniary estimation, the nature of the principal action or relief sought must be ascertained. If the principal relief is for the recovery of a sum of money or real property, then the action is capable of pecuniary estimation. However, if the principal relief sought is not for the recovery of sum of money or real property, even if a claim over a sum of money or real property results as a consequence of the principal relief, the action is incapable of pecuniary estimation. As the case of First Sarmiento Property Holdings versus Philippine Bank of Commerce, GR 102836. Now, for municipal trial court, exclusive original jurisdiction in all civil actions and probate proceedings, testate and intestate, including the grant of provisional remedies in proper cases where the value of the personal property, state, or amount of the demand does not exceed 2 million pesos, provided that if there are several claims or causes of actions between the same or different parties embodied in the same complaint, the amount of the demand shall be the totality of the claims in all the causes of action, irrespective of whether the causes of action arose out of the same or different transactions. What else? Note that under RTC, all actions which are incapable of pecuniary estimation are cognizable by the RTC except the annulment of judgment of the RTC, which is cognizable by the CA. That's Section 9, Number 2 of the BP 129, and revival of judgment of the MTC, which falls within the jurisdiction of MTC under summary procedure. In all civil actions which involve the Title II or possession of real property or any interest therein, where the assessed value exceeds 400,000 pesos, would be under RTC. Note, this does not include forcible entry into an unlawful detainer of lands or buildings, since original jurisdiction over which is exclusively conferred upon the Metropolitan Trial Courts and MTC, in cities, municipal trial courts, and municipal circuit trial courts. In all actions in admiralty and maritime jurisdiction where the demand or claim exceeds 2 million pesos, RTC. In all matters of probate, both estate and intestate, where the gross value of the estate exceeds 2 million pesos, RTC. In all actions involving the contract of marriage and marital relations, RTC. In all cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising jurisdiction, or any court, tribunal, person, or body exercising judicial or quasi-judicial function, RTC. In all civil actions and special proceedings falling within the exclusive original jurisdiction of a juvenile and domestic relations court and of the Court of Agrarian Relations as now provided by law, should be RTC. In all other cases in which the demand of the value of the property in controversy exceeds 2 million pesos, RTC. The gross value claim or demand is exclusive of interests, damages or whatever kind, attorney's fees, litigation expenses, and costs, IDALEC, the amount of which must be specifically alleged, provided that these charges or fees shall be included in the determination of the filing fees. The exclusion of the term damages of whatever kind applies to cases where the damages are merely incidental to or a consequence of the main cause of action. However, in cases where the claim for damages is the main cause of action or one of the causes of action, the amount of such claim shall be considered in determining the jurisdiction of the court. Again, so however, in cases where the claim for damages is the main cause of action or one of the causes of action, the amount of such claim shall be considered in determining the jurisdiction of the court. That is Administrative Circular 9-94. Under Section 5.2 of the Securities and Regulation Code, to hear and decide cases involving devices or schemes employed by or any acts of the board of directors, business associates, its officers, or partnership amounting to fraud and misrepresentation, intra-corporate controversies, controversies in the election or appointment of directors, trustees, officers, or managers of corporations, partnership, or associations, petitions of corporations, partnership, or associations to be declared in the state of suspension of payments. Special. No, let's go back to MTC. Under MTC's jurisdiction, the gross value claim or demand is exclusive of interest. The same with RTC, damages or whatever kind, attorney's fees, litigation expenses, and costs, the amount of which must be specifically alleged, provided that damages, attorney's fees, litigation expenses, and costs shall be included in the determination of the filing fees. Note the exclusion of term damages of whatever kind applies to cases where the damage are merely incidental to, just like in RTC, or the consequence of the main cause of action. However, in cases where the claim for damages is the main cause of action or one of the causes of actions, the amount of such claim shall be considered in determining the jurisdiction of the court. In cases of forcible entry and unlawful detainer, that's MTC, if the defendant raises the question of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership, the issue of ownership shall be provisionally resolved only to determine the issue of possession, so provisionally resolved. In all civil actions which involve title to or possession of real property or any interest therein, where the assessed value of the property or any interest therein does not exceed 400,000 pesos, because if it exceeds, that's RTC, exclusive on interest, damages, or whatever kind, attorney's fees, litigation expenses, and costs, provided that in cases of land not declared for taxation purposes, the value of such property shall be determined by the assessed value of the adjacent lot. In Admiralty and Maritime actions where the demand or claim does not exceed 2 million pesos, MTC, inclusion and exclusion of voters, MTC. Petition for habeas corpus and application for bail in criminal cases in the absence of all RTC judges in the province or city, it can be done in the MTC. That's a delegated, like all cases decided by the MTC, METC in their respective territorial jurisdiction except decisions of lower court in the exercise of delegated jurisdiction. Appellate of the Regional Trial Court, all cases decided by the METC, MTC, and MTCs in their respective territorial jurisdiction except decisions of lower courts in the exercise of delegated jurisdiction. Concurrent jurisdiction of RTC with SC would be actions of setting ambassadors, public ministers, and consuls. With the Supreme Court and CA, petition for habeas corpus, petition for quo warranto, petitions for certiorari prohibition or mandamus against inferior courts and other bodies, and petition for continuing mandamus. With SCCA and Sandiganbayan, that would be petitions for writ of amparo, petitions for writ of habeas data. And with the Insurance Commissioner, single claim not exceeding 5 million, otherwise known as an act strengthening the insurance industry. Jurisdiction is not the same as the exercise of jurisdiction. As distinguished from the exercise of jurisdiction, jurisdiction is the authority to decide a case and not the decision rendered therein. Where there is jurisdiction over the person and the subject matter, the decision on all other questions arising in the case is but an exercise of the jurisdiction, and the errors which the court may commit in the exercise of jurisdiction are merely errors of judgment, which are the proper subject of an appeal. The lack of jurisdictional envisioned in Rule 47 is the total absence of jurisdiction over the person or of a party or over the subject matter. When the court has validly acquired its jurisdiction, annulment through lack of jurisdiction is not available when the court's subsequent grave abuse of discretion operated to oust it of its jurisdiction. Thus, petitioners could avail of either an action for annulment of judgment under Rule 47 or an action for reconveyance. The proper action would be dependent on the ground the petitioner would invoke in questioning the July 7, 1980 in the case of heirs of Boras versus heirs of Boras, GR 213888, April 25, 2022. Unfortunately, petitioners erroneously filed a petition for annulment of judgment based on the ground of the trial court's exercise in excess of its jurisdiction, which is not a ground in an action for annulment of judgment. Penned by Justice Hernando. Jurisdiction once acquired is not lost and continues until the case is terminated. This is the case of Rizal Commercial Banking Corporation versus Plus Print. It says that as Court of General Jurisdiction, the RTC ordinarily exercise exclusive original jurisdiction over civil actions incapable of pecuniary estimation, such as that of accounting, cancellation of certificates of sale issued in foreclosure proceedings, and injunction. Nevertheless, the scope of such a general jurisdiction cannot be extended over matters falling under the special jurisdiction of another court or quasi-judicial body. Plus Print invoked the special jurisdiction of the SEC when it elected to file the SEC's petition. It cannot be gainsaid that it was Plus Print who sought the suspension of payments in connection with its outstanding financial accommodations with RCBC. By doing so, Plus Print necessarily placed the assets securing this financial accommodation under the SEC's special jurisdiction. Considering that the SEC already acquired jurisdiction over the financial accommodations and securities subject of Plus Print's subsequent RTC's complaint, the RTC erred when it proceeded to act on it while the SEC petition remained pending. To stress, jurisdiction once acquired is not lost and continues until the case is terminated. Thus, in cases where, as this one, a petition for suspension of payments is filed before the SEC, it acquires jurisdiction over the action and all matters relating thereto to the exclusion of the RTC. Concurrence of jurisdiction should follow the hierarchy of courts. This is Leonis versus Corpus, GR 204-106, November 17, 2021, by Justice Hernando. The Supreme Court's original jurisdiction to issue writs of certiorari is not exclusive. It is shared by this court with the regional trial courts and with the Court of Appeals. This concurrence of jurisdiction is not, however, to be taken as according to parties seeking any of the writs an absolute, unrestrained freedom of choice of the court to which application therefore will be directed. There is, after all, a hierarchy of courts. That hierarchy is determinative of the venue of appeals and also serve as a general determinant of the appropriate form for petition for the extraordinary writs. A becoming regard for the judicial hierarchy most certainly indicates that petitions for the issuance of extraordinary writs against first level courts should be filed with the regional. This is more of judicial hierarchy. But it's a policy that should prevent inordinate demands upon the court's time and attention, which are better devoted to those matters. Yeah, this is more. Jurisdiction over the parties is acquired through voluntary appearance without objection. And this is the case of Genetic Swine Improvements versus Thick and Thin Agri Products by Justice Hernando also. Whether an action is incapable of pecuniary estimation lies in the principal relief sought. So where the basic issue is something other than the right to recover a sum of money, the money claim being only incidental to or merely a consequence of the principal relief sought, the action is incapable of pecuniary estimation. This finds support in numerous decisions where this court proclaimed that the test to determine whether an action is capable of or incapable of pecuniary estimation is to ascertain the nature of the principal action or relief sought. Thus, if the principal relief sought is the recovery of a sum of money or real property, then the action is capable of pecuniary estimation. However, if the principal relief sought is not for the recovery of money or real property and the money claim is only a consequence of the principal relief, then the action is incapable of pecuniary estimation. First Sarmiento Property Holdings, Philippine Bank of Communication, June 19, 2018. An action to annul a compromise agreement is an action incapable of pecuniary estimation. An action to annul a compromise agreement is an action incapable of pecuniary estimation. This is a 2021 case, Aromin versus heirs of Sumi. Mere allegations of an agrarian dispute is enough to vest DIR jurisdiction over the case. Let's see. An action reivindicatoria is an action to recover ownership over real property, the jurisdiction of which is within the proper RTC. On the other hand, Section 50 of RA 6657 and Section 17 of Executive Order 229 vested upon the DAR primary jurisdiction to determine and adjudicate agrarian reform matters, as well as the regional jurisdiction over all matters involving the implementation of agrarian reform. Subsequently, EO 129A was issued wherein the power to adjudicate agrarian reform cases was transferred to the DARAB, and jurisdiction over the implementation of agrarian reform was delegated to the regional office. For DARAB to have jurisdiction over the case, there must be a tenancy relationship between the parties. For DARAB to have a jurisdiction over the case, there must be a tenancy relationship between the parties. In the instant case, in this case by D. Bunsho versus Ramos, respondents substantially alleged that there exists a tenancy relationship among the parties in view of their leasehold agreement. Furthermore, respondents claim that pursuant to said agreement, she and her husband, Hilario, have been paying the agreed rental of the land holdings to the lessors or Bunsho's parents. These allegations suffice for the referral of the dispute to the DAR as stated by law. Mere allegations of an agrarian dispute is enough to vest DAR jurisdiction over the case. Venue is a geographical location where suits are filed, while jurisdiction is conferred by law. Since the three elements are attendant in this case of Assis versus heirs of Caligna 1, GR 242127. Rosello indeed committed forum shopping. The argument that the properties are located outside Tacloban City and are thus outside the jurisdiction of the RTC of Tacloban City cannot be appreciated. Venue is the geographical location where suits are brought while jurisdiction is conferred by law. Despite the variance in the wordings of the reliefs, both complainants actually sought for reconveyance. In such a case, the property situated in a certain location may be part of the suit involving properties located in another place. Otherwise, it would result in the splitting of the cause of action and forum shopping, as it did in this case. In small claims, no evidence shall be allowed during the hearing which was not attached. What does that mean? In small claims, no evidence shall be allowed during the hearing which was not attached. Section 6 of the Revised Rules of Small Claims provides a small claim action is commenced by filing with the court an accomplished and verified statement of claim in duplicate, accompanied by a certification against forum shopping, splitting of single cause of action, and multiplicity of suits. This is Form 1A SCC small claims. And 2, duly certified photocopies of the actionable document subject of the claim, as well as the affidavits of witnesses and other evidence to support the claim. No evidence shall be allowed during the hearing which was not attached to or submitted together with the statement of claim, unless good cause is shown for the admission or addition or additional evidence. This is RCBC Bank Cards Services Corporation versus Oracion, June 2019 case. Failure to comply with barangay conciliation proceedings renders the complaint dismissible. Failure to comply with barangay conciliation proceedings renders the complaint dismissible. This is under Ngo versus Gabello, 2020 case. The court's lack of jurisdiction extends to ancillary writs, such as preliminary injunction, which exist only as an incident to an independent action. Bangko Filipino Savings and Mortgage Bank versus Bangko Sentral ng Pilipinas, 2021 case. So it says that the trial court with no jurisdiction over the petition filed therein is likewise devoid of any authority to act on application for the issuance of a writ of preliminary injunction contained in the same petition. Going back to MTC and METC on summary procedure in small claims. AM number 0887 SC Rules on Summary Procedure shall govern the expedited procedures in the MTC for the following cases falling within their jurisdiction. Under civil cases, forcible entry and unlawful detainer cases, regardless of the amount of damages or unpaid rentals sought to be recovered where attorney's fees are awarded, the same shall not exceed 100,000. All civil actions, except probate proceedings, admiralty and maritime actions, and small claims cases falling under Rule 4, where the total amount of the plaintiff's claim does not exceed 2 million, exclusive of the interest, damage of whatever kind, attorney's fees, litigation expenses, and costs. Complaints for damages where the claim does not exceed 2 million pesos, exclusive of the same above, interest and cost. Cases for enforcement of barangay amicable settlement agreements and arbitration awards where the money claim exceeds 1 million, provided that no execution has been enforced by the barangay within 6 months from the date of the settlement or date of receipt of the award, or from the date the obligation stipulated or adjudged in the arbitration award becomes due and demandable, pursuant to Section 417 of Chapter 7 of the RA 7160. Cases solely for the revival of judgment of any metropolitan trial court, municipal trial courts in cities, and municipal trial courts and municipal circuit trial courts pursuant to Rule 39. Summary procedure. Small claims. This is under AM number 887 Rules on Small Claims. It shall be governed by the expedited procedures in the MTC where the claim does not exceed 1 million pesos, small claims, exclusive of interest, that's small claims, for money owed under any of the following: contract of lease, contract of loan and other credit accommodation, contract of service, or contract of sale of personal property, excluding the recovery of the personal property unless it is made the subject of a compromise agreement between the parties. For enforcement of barangay amicable settlement agreements and arbitration award where the money claim does not exceed 1 million, provided that no execution has been enforced by the barangay within 6 months. Note, a small claim is an action that is purely civil in nature, where the claim or relief raised by the plaintiff is solely for the payment or reimbursement of a sum of money. It excludes actions seeking other claims or relief aside from payment or reimbursement of a sum of money and those coupled with provisional remedies. Under criminal case, this is under summary procedure: violation of tariff laws, rules and regulation, violation of the rental law, violation of the municipal or city ordinance, violation of Batas Pambansa 22. All other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 1 year or a fine not exceeding 50,000 pesos or both, regardless of other imposable penalties, accessories, or otherwise the civil liability. Family court. Family courts have exclusive original jurisdiction to hear and decide the following civil cases: petition for guardianship, custody of children, habeas corpus involving children. Note, the Supreme Court and CA have not been deprived of their original jurisdiction of such petition, Thornton versus Thornton. Petitions for adoption of children and the revocation thereof. Complaints for annulment and declaration of nullity of marriage and matters relating to marital status and property relations of husband and wife. Petitions for support and acknowledgement. Summary judicial proceeding under the Family Code and petition for declaration of the status of children as abandoned, dependent, or neglected. Petition for voluntary and involuntary commitment of children and matters relating to the suspension, cognizable under PD 603. Note, petitions for declaration of status of children as abandoned and neglected and petitions for voluntary or involuntary commitment of children now fall under the jurisdiction of the NACC. The jurisdiction of the Family Court for said cases pertain to those filed or pending before effectivity of RA 11642. Under the Family Code is deemed constituted, hence no need for its constitution. Family Code. The provision of RA 8369 reveal no manifest intent to revoke the jurisdiction of the Court of Appeals and Supreme Court to issue writs of habeas corpus relating to the custody of minors. Further, it cannot be said that the provisions of RA 8369, 7092, and BP 129 are absolutely incompatible, since RA 8369 does not prohibit the Court of Appeals and the Supreme Court from issuing writs of habeas corpus in cases involving the custody of minors. Thus, the provision of RA 8369 must be read in harmony with RA 7029 and BP 129. A special provisional remedies falling under the Family Court. In cases of violence among the family members living in the same domicile or household, the Family Court may issue a restraining order against the accused or defendant upon verified application by the complainant or the victim for relief from abuse, and the court may order the temporary custody of children in all civil actions for their custody support pending deleting, including deduction from the salary and use of conjugal home and other properties, and all civil action for support. Note that in areas where there are no family courts, the above-mentioned cases shall be adjudicated by the RTC. Aspects of jurisdiction. Jurisdiction over the subject matter is not conferred by court's unilateral assumption of jurisdiction, contract, compromise, agreement of the parties, erroneous belief of the court that it exists, acquiescence of the court, silence, waiver, or failure to object, and the court issuances. So jurisdiction of the subject matter is conferred by law and not by consent or acquiescence of any or all of the parties, or by erroneous belief of the court that it exists. That is from the case of Bilag. It is conferred by the Constitution or by law. Nothing can change the jurisdiction of the court over the subject matter. That power is a matter of legislative enactment, which none but the legislature may change. Exceptions would be estoppel by laches and estoppel by deed, or estoppel in pais. Estoppel by laches is established in the Tiham versus Sibong Hanoi case. Under the in Tiham, in summary, Tiham case applies to a party claiming lack of subject matter jurisdiction when there was a statutory right in favor of the claimant. The statutory right was not invoked. An unreasonable length of time lapsed before the claimant raised the issue of jurisdiction. The claimant actively participated in the case and sought affirmative relief from the court without jurisdiction. The claimant knew or had constructive knowledge of which form possesses subject matter jurisdiction. There would be irreparable damage that will be caused to the other party who relied on the form and the claimant's implicit waiver. Jurisdiction over the parties. It is the power of the court to make decisions that are binding on the parties. People versus People's General Insurance versus Guan Xing. It is acquired as soon as they validly file their complaints or petitions. It is acquired either through service of summons or through voluntary appearance in court and submission to its authority. By exception, defendant does not submit himself to the jurisdiction of the court when he specifically appears for the purpose of questioning the court's jurisdiction over him or her. This is Sabado versus Sabado. However, if defendant raises other grounds other than lack of jurisdiction over his person, he shall be deemed to have voluntarily appeared in court and jurisdiction over his person is acquired. Jurisdiction over the issue. It pertains to a tribunal's power and authority to decide over matters which are either disputed by the parties or simply under consideration. Jurisdiction over the issues is determined and conferred by either express or implied consent of the parties, by stipulations or of parties, as when in pre-trial the parties can enter into stipulation of facts and documents or enter into an agreement simplifying the issues of the case, by waiver or failure to object to the presentation of evidence on a matter not raised in the pleadings. How about the jurisdiction over the rest? It is the power of the court over an object or thing being litigated. The court may acquire jurisdiction over the thing by actually or constructively seizing or placing it under the court's custody. Actual is done by the seizure of the property under a legal process whereby it is brought into actual custody of the law. Example, attachment. Constructive is a result of the institution of legal proceedings in which the power of the court is recognized and made effective. Example, suits involving the status of parties or property of a non-resident defendant. Frias versus Al-Qaeda. How about the jurisdiction over the remedy? It is the court's competence over the process. Generally, jurisdiction over the remedy is provided by the rules of court, thus it is mainly a procedural matter, which the Supreme Court, the authority that promulgates the rules of court, may change ad hoc or clarify the application or interpretation of in proper cases. This is in the case of Philippine Long Distance Telephone Company versus City Appliance.